Good morning everybody. Namaskar. This is Engineer Suraj Singh speaking from Bharat, India on this November 20, 2021 Saturday. आप सबको नमस्कार. मैं हूं सूरज सिंह. And I am back to you to continue my my interaction about quality and safety, गुणवत्ता और सुरक्षा तथा किस तरह से हैंडल किया जाए क्वालिटी को, सेफ्टी को. और कुछ डिस्प्यूट्स भी होते हैं, झगड़े कॉन्ट्रैक्ट्स पे. टाइटल इज सिविल फील्ड इंजीनियरिंग लाइफ engineers quality and contracts, of course construction. So many topics are there. बहुत से विषय हैं जिनके बारे में थोड़ी थोड़ी बातें की जाएंगी. इंजीनियरिंग में, ज़िंदगी में, जीवन में, अभियांत्रिकी में, गुणवत्ता में, सेफ्टी में, कॉन्ट्रैक्ट्स में, कंपनियों के चाल चलन में, संचार कैसे हो, कोऑर्डिनेशन कैसे हो, तालमेल कैसे हो, निर्माण में, उत्पादन में, फैक्ट्रीज में, साइट्स पे क्या होता है, कैसे होना चाहिए, और अभियंता वर्ग, इंजीनियर वर्ग क्या कर सकता है, क्या नहीं कर सकता है. सर्टिफिकेट्स सच एज दिस वन, कॉम्पिटेंसी, सक्षमता बताता हुआ ये सर्टिफिकेट इंडिकेटिंग कॉम्पिटेंसी ऑफ पर्सन. दिस इज माई आइडेंटिफिकेशन, यू कैन से माई नेम बोर्ड where and this is another certificate that is chartered engineer. Of course this is a normal competency certificate. Normal, I mean to say it is regulated one for which one has to be corporate member. ये ऐसा प्रमाण पत्र जो है नियम के हिसाब से, चार्टर के हिसाब से कॉर्पोरेट मेंबर्स को मिलने वाला. और ये कॉर्पोरेट मेंबर का फेलो लेवल का सर्टिफिकेट, प्रमाण पत्र. और ये क्वालिटी का एक तरह का स्टैंडर्ड फाइल. आई नाउ कॉल इट स्टैंडर्ड फाइल ऑफ डेफिनेशन ऑफ क्वालिटी एंड सेफ्टी. क्वालिटी एंड सेफ्टी, गुणवत्ता और सुरक्षा, ये बताने के लिए कि गुणवत्ता नहीं है, वो चाहे उत्पादन हो, मैन्युफैक्चर हो, निर्माण हो, सेवाएं हो. गुणवत्ता कहाँ है, मैं ढूंढता ढूंढता थक गया, मुझे नहीं मिली. आई हैव गॉट टायर्ड कीपिंग माई सेल्फ बिजी इन सर्चिंग लोकेशन ऑफ क्वालिटी, but I failed to find address of quality. I don't know location of that. GPS is not working. My GPS of searching is not working about, and it doesn't know how to get quality, how to see quality. My communication has failed. My coordination has failed to find where does it live. मेरी कह सकते हैं आप संचार व्यवस्था, मेरी तालमेल की व्यवस्था, संतुलन की व्यवस्था फेल हो गई, असफल हो गई. क्वालिटी, गुणवत्ता का एड्रेस पाने के लिए ना ईमेल से मिला, ना वेबसाइट से मिला, ना वो किसी और तरीके से मिला. अंधेरा अवश्य मिला गुणवत्ता में, रोशनी किधर है मुझे नहीं मालूम. I did not know where a light exists. I tried to find, but I got complete darkness in a sphere of quality. That's the only reason that I am little unhappy. मैं नाखुश हूँ थोड़ा सा, क्योंकि मुझे क्वालिटी का पता नहीं मिला. I could not find coordinates of quality. Therefore my communication and coordination have been outdated now. I don't know how it's happening. what is happening, why communication is failing and why coordination doesn't work. I don't know. मुझे नहीं मालूम कि कम्युनिकेशन किसे कहते हैं और संतुलन किसे कहते हैं. I could not learn it in my university. Nobody taught me. I learned English, mathematics, other subjects, but I don't know. There was no professor in my university, my institution, to teach me about communication and coordination. And that I think is a major issue. That is only reason that I try to write here communication and coordination, so that at least few people can read it, because I don't know whether people know how to read or whether people know how to write. क्या अब लोग जानते हैं पढ़ना किसे कहते हैं, लिखना किसे कहते हैं? शायद लोग नहीं जानते. इसीलिए कम्युनिकेशन और कोऑर्डिनेशन एक ऐसी मंजिल पे पहुंच चुकी है. Communication and coordination has reached to such a level that there is one deception, one device, one deceptive device, or you can say one intriguing device, एक षड्यंत्रकारी डिवाइस. एक षड्यंत्रकारी डिवाइस काम कर रही है. One device that is known by name mobile. That mobile has thrown away power of my communication. It has thrown away power of my coordination. And it has made me a parrot, a crow. मुझे एक तोता बना दिया, एक कौवा बना दिया इस मोबाइल ने. मैं इससे अपनी जान छुड़ा नहीं सकता. I cannot run away from this mobile. It is such an attractive enemy for me. I am calling it enemy. That's why I'm saying it disturbs me whenever I concentrate. जब भी मैं एकाग्रता में जाता हूँ, ये मोबाइल डिवाइस, आई डोंट नो मोबाइल, व्हाट इज मोबाइल हेयर, व्हाई पीपल गिव इट नेम मोबाइल. It is not mobile, it is futile. It is fire for me. Kids, small infants, they all play it as it is food. And they all play with it. We had to study small books in our infancy time, and that was Qaida, Kunji, small booklets or photographs. But now every book is contained in this device through internet, and that's where I'm really concerned. Where is quality? Where is Gunvatta? Do we know how to read? Do we know how to write? Can I read now? People do not have any interest in reading and writing. You can see postings on Facebook, postings on LinkedIn, or postings on even lower profile sites. You shall find only photographs. This is my birthday party. This is my seminar. This is where I am getting award. You shall find only 2 to 3% or even 1% people who can use writing, who can think over. Thinking has been converted to photographs. Even if there is no requirement, people post. I don't know reason for that. Okay, posting is not bad. You can publish your photograph. There is nothing wrong. But can you use your mind? Can you share information of your life? क्या आप अपनी ज़िंदगी की सोच, आपने ज़िंदगी की शक्ति लोगों को दे सकते हैं? क्या फ़ोटो से आपको शक्ति मिलेगी या उनको शक्ति मिलेगी? मैं अपने बर्थडे का फ़ोटो लगा दूँ, अपनी शादी का फ़ोटो लगा दूँ, अपनी किसी और चीज़ का फ़ोटो लगा दूँ, उससे क्या होगा? खुश होंगे आप देख के, आपके दोस्त, आपके रिश्तेदार, दे शैल बी हैप्पी, योर फ्रेंड्स, योर रिलेटिव्स. बट वेयर योर नॉलेज इज, वेदर यू कैन रीड or you can write, that information is not available. This means education has gone away. Even I have seen very high profile people like engineers, like doctors, like professors. They only post photographs. Oh, see, I am getting this award, this is my award. All right, you are awarded. But whom you are telling this? You tell about award. You tell about your achievements so that other people can understand. No, no, this is my photograph. I know your photograph. I have seen what I do with this. My question is that it is public posting, public telecommunication. It is public. You can say public platform. After seeing your photo, what I should do? No way, nothing. So, my dear friends, my question is a little different. I'm not saying don't do this, but something should have some objective. If I don't have any objective, I think there is no meaning. There is no meaning in doing all this. Life should be having some objective. When I was young, I think I'm 55 born, 1955. In those days, life had some aim. So whatever aim, kids had something to say, okay, we have to get this, we have to go to this level, we have to achieve this, and that was called ambition in life. Now, if you do not know how to write, I have not seen any good writing from even very highly qualified students, highly qualified engineers, highly qualified doctors, highly qualified professors. They raise questions as if they don't know phrasing of questions. So this means communication is somewhere doesn't exist. It doesn't exist. Communication doesn't exist. And I am also breaking my English, you see, because practice is out of date. You complain for some service to some company whose product you are using. आप किसी ऐसी कंपनी को जिसका आप प्रोडक्ट का यूज़ कर रहे हैं, सर्विस के लिए लिखें, किसी बात के लिए लिखें, कोई कंप्लेंट करें, immediately you get a call. They want to know what's the problem. You have written problem, you have given every information, but then you get a call. What is your problem? Well, what does it mean? क्या मतलब है इस बात का? मैंने मेल में सब लिख दिया, क्या प्रॉब्लम है, मुझे आपकी सर्विस की क्यों आवश्यकता है, इस प्रॉब्लम को ठीक कीजिए. उसके बाद भी फ़ोन आता है, भाई क्या प्रॉब्लम है. इज इट ए वर्ल्ड ऑफ स्टूपिड पीपल? आई डोंट नो. आपको पढ़ना नहीं आता और एक फ़ोन नहीं आएगा, कई कई बार आएंगे. अजीब सा लगता है. इतना बड़ा देश भारत, इंडिया, जिसमें कहते हैं हम बहुत पढ़े लिखे हैं, बहुत ज़्यादा इंजीनियर, डॉक्टर, प्रोफेसर, बीए, एमए, सीए, ऑल, यहाँ करोड़ों लोग हैं जो नॉलेज रखते हैं. कैसी नॉलेज रखते हैं मुझे नहीं समझ आया. शोर, मोबाइल पे, मेट्रो में जाएं, पैदल जाएं, मोबाइल में लोग ऐसे चिपके हुए हैं जैसे वो शायद मोबाइल के लिए पैदा हुए हैं. मोबाइल का मतलब क्या है? मोबाइल को यूज़ करना या मोबाइल के साथ रहना? अगर हम इतने बिजी हैं, इतने व्यस्त हैं, तो हमारा देश तो बहुत आगे होना चाहिए था. एक ऐसी बीमारी पाल ली हमने जिसको कहते हैं मोबाइल. फिर लोगों के फ़ोन भी हैक होते हैं, फिर कहते हैं हमारा बैंक से पैसा निकाल लिया गया, हमारे साथ ये नुकसान है. भाई, आप मोबाइल को इतना क्यों चाहते हो? मोबाइल का मतलब फ़ोन से है, उसको लिमिटेड यूज़ करो. दिमाग की शक्ति को क्यों क्लोज करते देते हो मोबाइल के द्वारा? मैं ना तो मोबाइल का विरोधी हूँ, किसी चीज़ का विरोधी हूँ. मैं भी मोबाइल का प्रयोग करता हूँ, मैं इंटरनेट का प्रयोग करता हूँ. इसका मतलब ये नहीं कि मैं उसको गुलाम हो गया हूँ. कम्युनिकेशन एंड कोऑर्डिनेशन मस्ट एक्सिस्ट. मोबाइल इज ए मीन्स ऑफ कम्युनिकेशन, बट इट इज़ नॉट ए मीन्स ऑफ कोऑर्डिनेशन. कम्युनिकेशन भी आप एसएमएस भेज के कर रहे हैं, बातें करके कर रहे हैं, लंबी लंबी बातें, 2-2 घंटे बातें कर रहे हैं लोग, 3-3 घंटे बातें कर रहे हैं लोग, सारी सारी रात बातें कर रहे हैं लोग. यही तो वो लोग चाहते हैं कि आपका दिमाग खराब कर दिया जाए. आपके दुश्मन जो बिजनेस में बेचना चाहते हैं इस देश के युवाओं को, वो यही तो चाहते हैं कि आप सोचे नहीं. आप याद रख लेना, ज़्यादा मोबाइल यूज़ करने के बाद आपकी सोचने की शक्ति कम होती है. कीप इन माइंड, एक्सेसिव यूज़ ऑफ मोबाइल leads to reduction in power of thinking and power of concentration. If you call 10 persons, they will respond to you. You shall talk to you, and whole day you talk to them or half day you talk to them. You keep on talking and talking and talking. What happens? You cannot remember anything. You shall remember this point in another call and that point in your call. Means there's a complete mix up. You don't even know how to take action. And then you don't take action or you take wrong action. And that happens. Call has become as if you can call anybody. You can call whomever. Okay, this is what these companies do. They call you for nothing. Do you need credit card? Are you having any necessity of loan? Or is a club? Or it is a hotel? My God, I have nothing to do with you. Why you call me? Send your representative, let him market something, and that's the way it was for you, just using mobile services to disturb people, to interrupt them. This means communication has become a devil. I can say communication has become एक शैतान बन गई है communication. जो होना चाहिए वो तो नहीं हो रहा, जो नहीं होना चाहिए वो हो रहा है. क्या कहें इसको? ये बात को समझाने के लिए मैं समय तो खराब नहीं कर रहा आपको, मैं समझता हूँ, लेकिन ये समझाना बहुत जरूरी है. Communication and coordination are very important subjects, very important domains, though these are not formal domains, but these are important domains. You cannot do anything without them. Whatever activity we do in life, हम जो भी जिंदगी में काम करेंगे वो कम्युनिकेशन और कोऑर्डिनेशन के बिना नहीं हो सकता. Communication may be between two persons or maybe within yourself. Coordination can be on whatever topic, whatever subject, whatever work we have to do. हमें संचार करना है अपने आप से, अपने दोस्तों से, अपने लोगों से, दो व्यक्तियों के बीच में. हमें कोऑर्डिनेशन करना है किसी काम को करने के लिए, और बिना कोऑर्डिनेशन काम नहीं होता. जैसे हमारा शरीर बिना कोऑर्डिनेशन नहीं चलता, हमारे माइंड का हमारे ऊपर, हमारे हाथ पर, हमारे दिमाग पर, हमारे दिल पर क्या असर होता है हम जानते हैं. काम काम है, वर्क इज वर्क. यू कैन नॉट अवॉइड दैट. इफ वर्क इज नॉट डन परफेक्टली, यू वेस्ट नेचर, you waste your time, you waste your money. And work can be done only by concentration, even if this is a work where mind is not used. But some mind may be used. So you have to concentrate on that. Ekagrata jaruri. I'm just trying to explain to you what I mean by that. I know everybody knows, but I'm just keeping these certificates off now because unnecessary opening. Okay, now we have to achieve quality, and that work is done by people. It can be done through persons, it can be done through groups, or it can be done through companies. And contracts are world of time. Contracts cannot be avoided due to certain reasons, particularly for major projects where responsibility is involved. Responsibility, obligation, accountability, liability. You can say different words, different terms. जिम्मेदारी, हमें क्या करना चाहिए, क्या करना है, हमारा इसमें क्या जवाबदारी है, उत्तरदायित्व है, और हमारी क्या इसमें कानून के हिसाब से, नियम के हिसाब से नुकसान हो सकता है, पेमेंट देनी पड़ सकती है अगर हमने सही नहीं किया. और कंस्ट्रक्शन, निर्माण जिसको कहते हैं, इसमें तो क्वालिटी के हिसाब भी बस कितना होना चाहिए और कितना है उसका अंतर हम समझते हैं. व्हाट इज हैपनिंग, व्हाट हैपन्स इन रियलिटी, एंड व्हाट शुड हैपन, वी अंडरस्टैंड बोथ. दिस गैप इज वाइडनिंग एवरी डे. इट्स नॉट बीइंग ब्रिज्ड. गैप बिटवीन quality requirement and quality being produced is enlarging. Its span increases every day. While there should be no span, both should be at same coordinate, but these do not stay as such in 98% cases. And that's my point of concern. Quality कितनी है और कितनी होनी चाहिए, इसमें गैप नहीं होना चाहिए, क्योंकि दोनों एक ही चीज़ है. जितनी क्वालिटी होनी चाहिए उतनी होनी है और है. लेकिन ये कल्पना में है, विश्वास नहीं। मैंने कहा क्वालिटी क्यों नहीं है? वाई डज क्वालिटी नॉट एग्जिस्ट? शुड यू नॉट आस्क ए क्वेश्चन टू योर सेल्फ? आपको क्या अपने से प्रश्न नहीं करना चाहिए? क्वालिटी चाहे निर्माण में हो, उत्पादन में हो, सेवाओं में हो, शिक्षा में हो, समाज में हो, व्यक्ति में हो, संचार में हो, तालमेल में हो, क्या कहते हैं, या कहीं भी हो, किसी भी लाइफ के कार्य में, अभियंत्रण में, जो कि बहुत ज़रूरी है, चिकित्सा में, कोई ऐसा काम बता दीजिए, कोई ऐसा काम बता दीजिए जहाँ क्वालिटी नहीं होनी चाहिए, सिक्योरिटी नहीं होनी चाहिए, सेफ्टी नहीं होनी चाहिए। ऐसा कोई ज़िंदगी में जगह है? माई आंसर इज़ नो, एंड वट इज़ योर आंसर? आई डू नॉट नो। Life is engineering based, which means engineering is very important domain, like medical is super domain. और मेडिकल के बिना हम नहीं जी सकते, हम नहीं स्वस्थ रह सकते. We cannot stay healthy without medical. Same way, we cannot stay in good life, in good living without engineering domain, because engineering is very significant for everyone. Even for medical, engineering is very important. So why I talk about this? What should you do? Don't you think, must ask yourself, do you think you have some way out of not having quality? Do you think that without quality, compliance and its applications, can you do something? What should be your answer? You have to decide. I'm not talking to those people who don't understand it. I'm talking to elite people, like engineers, like professors, and whoever else has certain direct role in system and system involved activities. सिस्टमों में, उनके कार्यों में जो लोग व्यस्त हैं, इन्वॉल्व हैं, लिप्त हैं, वो लोग क्वालिटी को कितना एंगल से लेते हैं, what angle they understand quality should be, what percentage they should achieve, it's those people must decide. Engineering is a different world. Engineering or engineers are, you can say, I'm not saying distinguished, I'm saying, of course, they are different people in a way that, first of all, based on their academics and their reliable experience. Combination of two amounts to highest level of significance to create life standards. It is very easy to say quality. It's very easy. But its compliance, its requirements, its implementations are very difficult, because continuous focus is required on to quality objective. Because if you don't get quality object, your object is meaningless. Of course you will sell, it will give you profit, nobody will point out anything, because maybe one has to use for a couple of months or years. Only then one can know about health of quality of that product. And when one knows that it doesn't comply to one's requirement, one may curse, one may say very bad about that product or company, or maybe there is no option. Maybe there is no option, but nowadays competitions are very high. What I mean to say, if you want to not only survive, if you want to enjoy product, enjoy life, quality cannot be avoided, and people claim only that this is quality product, but either they do not know what is quality or they don't read what it should be, and that's the only reason I said communication and coordination. These are part of quality, and in fact these are leads of quality. If I want to do work, I have to know what is design about that. Whatever work it is, I want to know that. What is design, what I have to do, what materials are required, what equipment are required, what you can say process is required, or how many people and what classes of people are required. All this information is used in every activity in life. It's not engineering alone, it is everywhere. It is everywhere in every activity of life. And if we know that, what is procedure, what is content, how can we do this, means what is specification of its doing, everything has specified. Maybe something is written, something is not written, but convention specifies something. And we cannot avoid compliance of quality. हम क्वालिटी कंप्लाई ना करें, ज़्यादा नहीं चलता, और जो चलाना चाहता है वो समाप्त हो जाता है। गुणवत्ता अभियंताओं के हाथ में होती है और उसे लागू करना होता है, करना होगा। क्वालिटी को डिफाइन करना बहुत आसान नहीं है, बहुत मुश्किल भी नहीं है। क्वालिटी समय के हिसाब से आती है, एक्सपीरियंस से आती है। जरूरी नहीं जो लिखा है वो सब सही हो, ये भी फैक्ट है, लेकिन उसका सुधार तो किया जाता है। जब तक आप काम नहीं करेंगे, एक्सपीरियंस नहीं करेंगे, आपको समझ ही नहीं आएगा। एक्सपीरियंस इज़ वेरी सिग्निफिकेंट। इफ़ वी आर एक्सपीरियंस ऑफ बैड वर्क, वी शैल डू बैड वर्क, otherwise we shall do good work if we have experience of good work. But I can say those people who have money, who are in business, who are in commerce, who are in manufacturing, or wherever they are in contracting or promotion, generally they people believe only in money making. They do not believe in standards. Of course they will not say we don't believe, but they would not consider very seriously whatever company they are, national or international. This, you can say, hunger for making more money has spread throughout the world. So quality also varies. I don't say all world is not giving quality. There are some good countries who are serious about quality, and there are not good countries like Bharat, India, and many more such countries around us, and also in other parts of the world where quality got no meaning. I don't call them good people who don't give quality. I call them stealers, thieves and robbers, whoever they are. Even if they are engineers, even if they are professors, even they are whoever they are. If they are careless, they are ignorant, they don't care for people, they don't care for product, because they are against enemy, they are against our nature. You do not have any product. You have manufactured yourself. Manufacturing is done based on natural materials. Without availability of natural materials, raw materials, manufacturing cannot be done and nothing can be done. So we play with nature. We have to link it like this. And that is what I say coordination. There is no excuse that can be granted for failure on quality. Quality is like our breath, like our heart, like our mind. And engineering and engineers are tools, automatic tools you can say, that can change world. Quality is a must and must. Engineers have to realize this fact. They have to change. They have to change for sake of quality achieving. And they are responsible. they are responsible, and first responsibility goes to civil engineers, while all others too are responsible to projects, to works. I'm not going to talk at length at this because every day I like to talk something so that you should not forget quality, because quality can never be and must not be compromised by engineers and public. संचार तथा संतुलन अत्यंत आवश्यक। सही गुणवत्ता पाने के लिए इसको हटाया नहीं जा सकता, इसके साथ समझौता नहीं किया जा सकता इंजीनियर्स के द्वारा, पब्लिक के द्वारा। संचार हो, संतुलन हो, अगर हम इससे भागेंगे, हम किसी से नहीं भागेंगे, अपने आप से भागेंगे। ये बात बहुत सिग्निफिकेंट है। मैंने देखा है आजकल कोई भी इंटरेस्टेड नहीं है, नो वन इज इंटरेस्टेड इन राइटिंग्स, इन रीडिंग, इन ट्राइंग टू meet all points, all works at one point. Means everybody is on its way just to leave it in between and not to give results. We have to change a little. Excess, or you can say excessive use of every device is not good. We know that. My explanation is that we should be serious enough to involve ourselves in many activities of life, not just superficial activities but detailed activities. I'm finding everyone is superficial. Everybody is behind money. Money has become objective of everyone. I'm saying 95 to 98% people. Money is their God. Okay, that's fine. But if you want to have money, you have to have good controls. If you want to have good economy, you must have good controls and commands. But those commands and those controls are not available because you don't want to read anything. You don't want to record anything. You don't want to coordinate anything. In that case, how can we move? Life is full of speed, full of rapid movement, and that acceleration must work. But if you do not control your car while driving 160, 140, 150, and by chance there is an error, there is a deflection of your mind from concentration at car and think of something else, what shall happen to you? I don't need explain that. I am talking to minds. I am not talking to legs. That's what I have to say. There are problems in life. There are misunderstandings in life. And there are selfish nature, social nature, every nature available. You are selfish, or I am selfish, or I am society oriented. If I am society oriented, I cannot be selfish. Yes, selfish means for your own interest, you can say. That's not called selfish, that's called requirement. For your personal requirement, for your commercial requirement, for your own individual requirement. There's a one way, and for social requirements, that's another way. You have to live, that's true. I have to live, you have to eat, means for that it's okay. But beyond that, it's not okay. मेरा कहना है थोड़ा सा बदलिए, पढ़िए, लिखिए, भूल जाइए कंप्यूटर को थोड़ी देर के लिए, याद कीजिए उस समय को जब कंप्यूटर नहीं था, कितना काम करना पड़ता था हमें कितना काम करना पड़ता था, सोचो जरा, कभी कभी सोचो। कल्पना कीजिए कंप्यूटर नहीं है, कल्पना कीजिए टाइपराइटर भी नहीं है या बहुत कम है, कैसे काम करते होंगे लोग। मोबाइल तो भूल जाइए, टेलीफोन भी नहीं होता था, कैसे चलती थी दुनिया। What was speed of life? Think of that. But there was quality in life. People were serious, concerned. But now, every facility is available, but people are not serious. People are neither serious in studies nor in work. They are only serious in fulfilling formalities. Fulfilling formalities that this complaint was received. Why no action been taken? So what they do, they don't attend complaint, they just want feedback. It happened to me in many cases. It can happen to everybody. For example, if you want some service, you lodge a complaint. They will not care for complaint, they will care for feedback. Right? What is our feedback? Some people are there, some companies are there who don't care about whether complaint has been attended. But you will get many calls about feedback. I don't understand this logic. They will ask you, you filed this complaint, something happened? My goodness, it makes me crazy. I file a complaint with some company and then I start getting some calls after few hours. Did it happen? What's your feedback? My God, it didn't happen. Why are you asking me? Don't you know it's not happened? That is what I say. Coordination is not available. They just want to send back a message to you that your problem has been resolved. Only that. And it happens. It's very important from quality viewpoint that problem has been attended and resolved. They want to show on record. Is that life? Is that profession, you can say? Does any profession allow this? Don't worry about complaint, worry about feedback. And if some service people does service for you, for little service, say for half an hour in your home, for whatever appliance, and you say, okay, code number is given, everything is given, satisfied to this, then they will say, okay, you refer to our website and write about this. My God, what do you want? You want to show people how efficient we are? People use your material and then say, okay, refer to someone. Or can we write on Facebook? Can you use it on Facebook or some other site? For this, we did service for you and this is a good service. Means you want to use your customer as advertiser for you, right? Is customer living for that? Customer pays to you and you get money. That's your result. Why do you want that customer becomes your advertising agency? For that purpose. No, it's not acceptable. So my dear, my long talk, my some time consuming talk is not to discourage you, but to encourage you from certain points of views. I'm not against any use of communication if it is useful. If it's just wasting time, passing time, it's complete nonsense. Because it reduces your memory. आपको समझ नहीं आ रहा है, आप जितनी ज़्यादा बातें फ़ोन पे करते हैं, आपका माइंड उस तरफ हो जाता है, बाकी बातें भूल जाता है। अगर आप कंसंट्रेट नहीं करेंगे तो जवाब नहीं दे पाएंगे, और आप कंसंट्रेट करेंगे तो जो काम कर रहे थे वो रह जाएगा। ड्राइविंग करते वक्त भी नहीं मानते लोग, स्कूटर चला रहे हैं, कार को भी छोड़िए, साइकिल चला रहे हैं, चलो पैदल की तो बात और होती है, साइकिल चला रहे हैं, मोबाइल यूज़ कर रहे हैं, उसी टाइम जैसे बहुत बिजी हैं, स्कूटर बाइक चला रहे हैं तो भी मोबाइल यूज़ कर रहे हैं। अरे भाई, अपनी जान की चिंता करो, दूसरे की जान की चिंता करो। गिर जाओगे तो भी चोट लगेगी, दूसरे को मारोगे तो भी चोट लगेगी, उसको भी लगेगी, आपको भी लगेगी, मर भी सकते। तो आपने यहाँ तक कि आप एक्सीडेंट को दुर्घटना को निमंत्रण दे रहे हैं। क्या आप इतने बिजी हैं कि हर वक्त आपको मोबाइल की ज़रूरत है? बिना मोबाइल आप सांस नहीं ले सकते हैं। लोग बातें नहीं करते आजकल, मैंने देखा है। मेट्रो में कोई बात नहीं करता, कहीं कोई बात नहीं करता किसी से। भाई आप कौन हैं, कहाँ जा रहे हैं, क्या हाल है, क्या करते हैं। कई कई घंटे भी आपको जाना हो तो अपने लगे हैं सब चैटिंग में। क्या हो गया है? हम डिसइंटीग्रेट क्यों हो रहे हैं? मैं इसको डिसइंटीग्रेशन बोल रहा हूँ। सच है, हम टूट रहे हैं आहिस्ता आहिस्ता। हम ही नहीं, इस देश में नहीं, सब देशों में। पास बैठे हैं फिजिकली, लेकिन मेंटली कहीं और, मस्तिष्क कहीं और, दिमाग कहीं और। शरीर माँ बाप के साथ में, लेकिन बात नहीं। भाई बहन अपने अपने में लगे हैं, मियाँ बीबी अपने अपने में लगे हैं, जैसे वो हैं ही नहीं आपके लिए। क्या मोबाइल इस काम के लिए अच्छा है? छोटा बच्चा वीडियो देखे जा रहा है, छोटा सा बच्चा है कुछ वर्ष का, वो वीडियो ही देखे जा रहा है, उसे कोई रोकने वाला नहीं है। क्यों भाई? इसका क्या अंत होगा? कोई बताएगा? कोई नहीं बताएगा आपको, क्योंकि इसमें बताने जैसे कोई बात ही नहीं है। अंत तो होगा, कभी भी कोई चीज़ हमेशा के लिए नहीं होती। पहले भी बीमारी होती थी हमको ट्रांजिस्टर की, सड़क पे लेकर चल रहे हैं ट्रांजिस्टर, गाने सुन रहे हैं, विविध भारती सुन रहे हैं, सेलोन सुन रहे हैं, ऐसा था। लेकिन नहीं चला जाता। मैं ये नहीं कह रहा आप मोबाइल मत यूज़ करो, उसको यूज़ करो अच्छे काम के लिए। क्या वीडियो देखे जा रहे हैं लोग फिल्मों के, दूसरे पॉर्न? मैंने देखा है लोग न्यूज़ बहुत कम देखते हैं, न्यूज़ रिलेटेड वीडियो बहुत कम देखते, बहुत कम। कुछ लोग होंगे 2-3%, नहीं तो वही बेकार की बातें, कोई प्रोडक्ट नहीं, कोई आउटपुट नहीं। हमारे काम बहुत मुश्किल होते हैं इंजीनियरिंग में। इंजीनियरिंग इज ऑल, पर्टिकुलर सिविल इंजीनियरिंग इज दैट फील्ड वेयर वी कांट केयर अबाउट एनीथिंग बट वी हैव टू कंसंट्रेट ऑन प्रोजेक्ट। हमको अपने प्रोजेक्ट पे कंसंट्रेट करना होता है। करेंगे भी क्या? डिजर्ट में बैठे हैं, वी आर इन डिजर्ट्स। भाई डेवलपमेंट तो जंगलों में ही होती है, डिजर्ट में, अर्बन एरिया में तो बहुत कम, रूरल एरिया में होती है और रिमोट एरिया में होती है, डिजर्ट्स में होती है। डिजर्ट्स को सिटी बनाना है, जंगल को एक प्लांट बनाना है, तो कितनी मेहनत करनी होगी सोचिए। कुछ है नहीं, कुछ भी नहीं है, वहाँ से काम शुरू करना है। ग्रीन प्रोजेक्ट है, कई वर्ष लगेंगे, नहीं लगेंगे नहीं हो सकता, लगाएंगे समय तो हो सकता है। एंड फॉर दैट पर्पस engineering is branch, engineering is domain for development. But if engineers do not concentrate, they also work in same pattern as other people work. How shall it happen? I do not know. Can we get development? I do not know. It's really very interesting to know about this. We have to be very serious, in fact. Well, I'm not going to speak again on this. I'm now shifting on to my real, real. That's disputes. I was talking yesterday. Disputes in contracting. We call it arbitration. That is called dispute resolution. मध्यस्थता के द्वारा, आर्बिट्रेशन के द्वारा ये हम बात कर रहे थे कॉन्ट्रैक्टिंग में। और हम एक्ट को लेके भी बात कर रहे थे कि एक्ट क्या है। और फिडिक जो मैंने आपको दिखाया था, पहले मैं फिडिक दिखा देता हूँ जो हमने पढ़ा समझा और हम आगे चलना चाहते हैं फिडिक को समझने के लिए। और फिडिक में जो क्लॉज था आर्बिट्रेशन 21 क्लॉज डिस्प्यूट रिजोल्यूशंस का, उसके बारे में बात हम कर रहे थे और शायद अभी भी हम वहाँ पर एक तरफ कॉन्ट्रैक्ट है, कॉन्ट्रैक्ट में दो पार्टी हैं. वी हैव ए कॉन्ट्रैक्ट, कंस्ट्रक्शन कॉन्ट्रैक्ट, or it is EPC contract, engineering, procurement and construction. Whatever it is, if it is construction contract, it is related to Red Book, FIDIC Red Book. And if it is design and construction contract or EPC, it is related to silver, standard silver form, silver book. We have gone to both. We have gone to difference of both also. There's no major difference, but only difference is part of design and procurement. Procurement is also done in construction, but procurement what I'm talking is that's different. Procurement is not only material procurement, but also vessels and equipment, and you can say heavy machines procurement that constitutes part of contract. And in fact, design and construction contracts are very powerful if party of contracting world is powerful intellectually, not money wise. If you want to get some contract on EPC basis, then you cannot be small person. You cannot be small company. You must have caliber, physical caliber and design caliber. Only then you can get EPC or you can be entitled for that. And you must have lot experience. Experience as subcontractor, experience as contractor, and experience as designer. Combination of all these. Only then one can be qualified to become EPC contractor. And if you are only a contractor, construction contractor, then you must have long reputation in construction works. And of course, financial backing is required everywhere. So procurement I'm talking is very expensive world of machines, vessels, equipments that are used in, these are included permanently. Is something you can say that both parties on contract, one is called employer, other one is contractor. And there are so many clauses in every contract. And these clauses are well structured. These clauses content reasonable, logical phrasing of requirements. What are responsibilities of each party? Responsibilities, or you can say division of responsibility, DOR. What is the responsibility of employer? What is the responsibility of contractor? And what are responsibilities of others who are indirectly related to contract, like engineer. Engineer means not ordinary engineer, but engineer who is responsible for that contract on behalf of employer, and who has to decide about every part of contract, and also who has to design contract itself, who has to design works if it's EPC, and who has to take care of contract design wise or its implementation wise or administration wise. But this party, which is called engineer, can never be a party on contract, but it has got different contract with employer, which may be a contract of service or contract of employment or contract of whatever it is. That has nothing to do with contractor, but it has got relation to both, indirect relation, cohesive and adhesive both. Cohesive and adhesive both I am saying, try to understand this point. Engineer is employed by employer. It is employed either on fee basis or it's employed on remuneration basis. For contractor, nothing works. for contract, nothing to do with that. Engineer is not a party on contract, but it's a party on different contract. Contract between employer and engineer or employer's representative. Contract has got no such relation to engineer as well. Employer has employment relation, working relations, but as far as decisions on contract are concerned, decisions on technicalities are concerned, decisions of finances are concerned, engineer is not directly responsible. Yes, engineer becomes a support for everything. Without engineer, nothing moves. But contract is different. Therefore, only two parties exist on whatever contract there is. It is employer, or you can say owner, or promoter, or it's whatever name you give. Another one is contractor. Both are parties to contract. Party 1 is employer and party 2 is contractor. And supervision and administrative party is the engineer, but on different contract, not on this contract. It's like a third party, not exactly third party, but like a third party on this contract. And there's another third party also, which is formally known as third party consultant or third party, whatever it is. And they are also not linked to employer or contractor, but paid by employer. So we have to understand this point. And there are many more stakeholders on both ends, on employer end and on contractor end, because they are all companies or persons, you can say. So we have to see that there may be some conditions in contract, many conditions which is defining all parties, defining what are requirements, what are scope of work and everything. That definition exists in contract data. What price shall be paid for whatever work is also clearly defined, particularly on lump sum contracts, lump sum fixed price contracts. Everything is detailed out. That cannot be changed. But according to conditions, there are so many points which apply. Variations may be there, disputes may be there, misunderstanding may be there, whatever there. Everybody has right to speak and questioning before bidding is closed and questioning during project running, project currency. When I call project currency, means current duration of project, ongoing project, it's called currency. There can be whatever claims and counterclaims from both parties, on behalf of both parties. Those claims and counterclaims can be accepted and can be rejected. Now, engineer is first level of authority, or you can say representative, employer's representative, you can say. Actually, it is engineer, not exactly 100% representative, but representative for some reasons. For administration, for supervision, it represents on its own. On behalf of employer, because ultimately employer spends money, employer is responsible with support of engineer. And there are some areas where engineers can't interfere, like budget allocation and whatever items have been agreed for that. And if you want something additionally or where budget doesn't allow, then permission of employer is required. It's permission not for you, engineer, but for contractor. So contractor requires permission. Engineer is only involved in engineering and supervision. But there can be problems that in some case when engineer decides on behalf of contract, not on behalf of employer, decides something, and that decision, whatever it is not agreeable by employer as well as by contractor, that you can say it's kind of dispute. You can say there's misunderstanding, or there's no area, there's no point where both can agree. If both can agree, fine, that can be worked, that can work upon. But if they don't agree, then it is engineer who has to decide for them. Engineer can decide, but they may not accept. They may not accept. They shall. One of them may be dissatisfied, and we call them dissatisfaction party. No problem. You are not satisfied, but I can't do more than that. As an engineer, I have worked out that this part is your right and this part is your right for both of them. If they are not happy, there's no problem. There's another channel, another platform, and that's called DAB, DAAB, Disputes Avoidance and Disputes Adjudication Board, which is not mandatory everywhere, but if it's a provision in contract, it can be for major torts. So that problem can be brought to, that dispute can be brought to DAB for its recommendation or for its award. And even if you are not happy with that, ultimately, if your contract says it's an arbitration contract, arbitration is included within this contract. So only way left is to go to arbitration and have award from there. That is what arbitration is. दोनों पार्टियां, कॉन्ट्रैक्टर, एम्प्लॉयर, किसी भी बात पे खुश नहीं हैं, झगड़ती हैं, तो वो झगड़ा सुलझाएगा इंजीनियर। पर अगर इंजीनियर भी ना वो झगड़ा सुलझा पाए, तो वो जाएगा DAAB के पास, वो झगड़ा DAAB सुलझाए। और अगर DAAB भी नहीं सुलझा पाता, असंतोष क्रिएट होता है। तो जो पार्टी असंतोष में है, जो भागीदार संतोष में है, वो न्यायालय में, जिसको हम आर्बिट्रेशन कहते हैं, न्यायालय तो नहीं कह सकते, लेकिन न्यायालय से कम नहीं है। आर्बिट्रेशन कोर्ट नहीं है वो, लेकिन क्षमता वही है। आर्बिट्रेशन में जाए प्रोसीजर के हिसाब से और वहाँ से अपने हक को ले। वो हक चाहे दोनों पार्टी में किसी को भी मिलने हों, इसके होंगे उसको मिलेंगे। उसके बाद हम कहते हैं डिस्प्यूट को समाप्त हुआ आर्बिट्रेशन के बेस पे, और आर्बिट्रेशन का जो भी फैसला है वो उसी तरह से माना जाता है जिस तरह से कॉन्ट्रैक्ट डिस्प्यूट में या किसी और डिस्प्यूट में कोर्ट फैसला करे, कोर्ट अवार्ड दे, इतना होता है। इसलिए किसी भी इंजीनियर के लिए, क्योंकि इंजीनियर्स ने तो कॉन्ट्रैक्ट को डील करना ही करना है, इंजीनियर्स हैव टू डील विद कॉन्ट्रैक्ट, they have to work on contract to get works done. Therefore, it's very important point from professional viewpoint also, that we should know something about arbitration. And knowing arbitration means you are an engineer, well educated, well experienced, and also that you have knowledge of contracts. And having knowledge of contracts means having knowledge of certain interconnected regulations, interconnected statutes or laws, and those may be 4 or 5 or 6 laws, not more than that, in which we feel you are working related to that one. Human resources law common, machines law common, and whatever safety law, quality law, and whatever other laws that engineers know. And there are some more laws which may have to refer to from time to time, depending on specialization. Means whatever legal provisions do exist for your project, you cannot violate them. Neither contractor, nor employer, nor engineer, and nobody else, no one else can violate that. And we can have information about them, which is not very difficult. Maybe you do not get it immediately after passing your examination, but in your career, in your work, in your job, you may have to deal with that. And it's not in one day that you know everything, and it takes time and to follow up that one. That's when you can say engineer, in whatever category one is, has to first of all respect contract documents, respect contract provisions. We cannot jump out, we cannot isolate ourselves. People, engineering people, I am sure they're not very interested in non-numerical activities. I mean to say, they are happy in numericals work like designs. They're not happy in text activities. They think engineering means only calculations. And that's main problem. Means they want to work on softwares. They want to do every work with that. And that is sometimes a problem. And that causes problem. हर समय हम बिना सोच के तो काम नहीं कर सकते. कभी कभी ठीक है, ज़्यादा नहीं हुआ, एक्सपीरियंस है, कर दिया. अब हम बात कर रहे थे आर्बिट्रेशन की. आर्बिट्रेशन क्या है आफ्टर ऑल, हमने समझाया आपको. आर्बिट्रेशन में जाने का मतलब है हम कोर्ट में नहीं जाना चाहते और यही आर्बिट्रेशन का पर्पस है. इट्स क्लियरली रिटन इफ आर्बिट्रेशन एग्जिस्ट इन योर कॉन्ट्रैक्ट, आई हैव टू से इट इज़ ए कॉन्ट्रैक्ट ऑफ आर्बिट्रेशन, or we can name it arbitration contract, and both parties have power to appoint arbitrator for each of them, and once they decide and refer cases to arbitration tribunal, or single arbitrator or 3 arbitrators or 5 arbitrators, whatever it is. In that case, when dispute is referred to arbitration, and before that you can say a process is adopted, a trial has been made for amicable settlement, and if amicable settlement fails, it doesn't work out solution, then we have to go to dispute resolutions, or if DAB exists, then we have to use DAB services also. But ultimate is arbitration means your appointed people shall decide for you. You are appointed, I mean to say appointed by someone. In that case it is used, not relation, it doesn't have any relation. So that's what arbitration is, and it works all over the world. In construction projects, arbitration has got some space, and it of course is not time consuming like other cases, but because we don't have complete infrastructure of that. But even then, our hospitals are well competent, well consistent in doing this job. It is engineering world, contract is engineering world, so I think engineer should be preferred for such activity. It may be arbitrary position, arbitrator's position, or it may be position in design office or position in site office. But even if somebody doesn't have input, doesn't have sharing information about computer and internet, it's a good one. Well, it's not the way. I was talking yesterday about Act, Arbitration Act and its amendment. हमारा देश का एक्ट क्या है, हम उसके बारे में कल बात कर रहे थे. अभी हम जाते हैं उस एक्ट को फिर पढ़ने के लिए, आखिर वो था क्या. 1996 का एक्ट है. अभी हम उसको फिर खोलेंगे और उसके बाद इसको मैं शायद बंद कर देता हूँ. अभी सिल्वर को बाद में have in place, and then general condition dispute avoidance agreement. वो conditions क्या होती हैं वो भी हम ब्रीफली में बता देता हूँ आपको इसमें अभी, just to let you know what are general conditions of dispute avoidance adjudication agreement. And its definition is general conditions of disputes avoidance adjudication agreement. Then dispute avoidance adjudication agreement, DA agreement, its activities, its rules, its assistance, and term notification. Likewise, warranties. In this, warranties doesn't mean rents. DAB members warrants and agrees he shall will remain in time due, etc. etc. We'll go through that. Independence and impartiality, then general obligations, and of course general obligation of parties, then confidentiality, and of course you can say parties undertaking an indemnity, fees and expenses, and after that is under DA agreement, then procedures rules. So we will see this later on. So now this act, which is 1996, it was first time published, and this is again in 2016. It's that Ministry of Law and Justice. Separate paging is given to this part in order that it may be filed as a separate completion anyway. Following Act of Parliament, this is 2016. Following Act of Parliament received assent of President on 31st December 2015 and is hereby what amendments have been made, and also like this course definition, all these definitions. We cannot go to every amendment understanding, but major points we have to be clear about. We, as I said, that Arbitration Act, we have to find out Arbitration and Conciliation Act. Let us see how does work. It's now, this is other act which is definition of that one we have gone through, and we have gone through power of parties to refer to, okay, then entry measures by court we have gone through, comments etc. we have gone through, then we have gone through grounds for challenge and arbitration. This we have gone through challenging procedures. I am not going to do that. Failure of enforcement to act. So main provisions have been talked, means then it was competence of arbitrator tribunal to rule on it. So this is important one. Let us say this. So first let us take this point: termination of mandate and substitution of arbitrators. That's one point. Failure or impossibility to act. Okay, this is another point. And we say challenge procedures, and before that is grounds for challenge, and we can say that so much explanation sometimes there's no need, no load, just takes nowhere. Okay, appointment of arbiters. Let's start from here. This is appointment of arbitrators. Let's say what is that. Now it's appointment of arbitrators, section 11 of the set. Appointment of arbitrators, a person of whatever nationality. I'll discuss this also before. I've discussed a person of whatever nationality may be an arbitrator. Means there is no difference in nationality here. You can say person from all parts of world can become an arbitrator. दुनिया में कहीं भी कोई है उसको आर्बिट्रेटर बनाया जा सकता है, अनलेस अदरवाइज एग्रीड बाय पार्टीज. हाँ, अगर पार्टीज ने पहले फैसला किया हुआ है कि नहीं हमें ये नेशनलिटी चाहिएगी, वो अलग बात है. ए पर्सन ऑफ वट एवर नेशनलिटी मे बी एन आर्बिट्रेटर unless otherwise agreed by parties. I'm sorry. Now subject to subsection parties are free to agree on procedure for appointing arbitrator or arbitrators. I'm just talking of original act, बाकी बाद में पढ़ेंगे. दोनों पार्टीज फ्री हैं डिसाइड करने के लिए प्रोसीजर कि आर्बिट्रेटर को कैसे अपॉइंट किया जाए. नाउ इफ देयर इज नो एग्रीमेंट, फेलिंग एग्रीमेंट रेफर टू इन सेक्शन दिस टू an arbitration with 3 arbitrators. Each party shall appoint 1 arbitrator and 2 appointed arbitrators shall appoint 3rd arbitrator who shall act as presiding arbitrators. दोनों पार्टियों को अपना अपना चुनना है आर्बिट्रेटर कैंडिडेट, आर्बिट्रेशन कैंडिडेट, और दोनों पार्टी एक दूसरे के अप्रूवल के लिए. और जब दोनों चुने जाएं, इलेक्ट हो जाएं, तो वो अपने प्रेसिडेंटिंग ऑफिसर को इलेक्ट करेंगे. ये नियम है नॉर्मल. फेलिंग एग्रीमेंट रेफर टू इन सेक्शन 2 इन एन आर्बिट्रेशन विद 3 arbitrators. Each party shall appoint 1 arbitrator and 2 appointed arbitrators shall appoint 3rd arbitrator to act as presiding arbitrators. If appointment procedure applies and a party fails to appoint an arbitrator within 30 days from receipt of request to do so from other party, 2 appointed arbitrators fail to agree on 3rd arbitrators within 30 days from date of their appointment, appointment shall be made upon request of a party by Chief Justice or any person or institution designated by that Chief Justice. अगर दोनों पार्टियां अपने कैंडिडेट को अपॉइंट करने में, अपने आर्बिट्रेटर को अपॉइंट करने में फेल होती हैं, तो चीफ जस्टिस मुख्य न्यायालय, आपके चीफ जस्टिस जो मुख्य न्यायालय के मुख्य हैं, वो या कोई उनके द्वारा डेजिग्नेट किया हुआ व्यक्ति बनाया जाएगा. अगर फेलिंग एग्रीमेंट रेफर टू इन सेक्शन 2 an arbitration with a sole arbitrator, if parties fail to agree on arbitrator within 30 days from receipt of request by one party from other party so as to agree, appointment shall be made upon request of a party by Chief Justice or person or institution. Now, under an appointment procedure agreed upon by parties, जहाँ पर appointment procedure define किया गया है, where under an appointment procedure agreed upon by parties, a party fails to act as required procedure के हिसाब से, और parties or 2 appointed arbitrators fail to reach an agreement expected of them under this procedure. अगर दोनों आपके अपॉइंट किए हुए आर्बिट्रेटर्स आगे अपना नहीं अपॉइंट करते हैं प्रिजाइडिंग आर्बिट्रेटर, तो भी प्रॉब्लम है. फिर क्या है? ए पर्सन इंक्लूडिंग एन इंस्टीट्यूशन fails to perform that function entrusted to it under that procedure, a party may request Chief Justice or other person or institution designated by it to may take necessary measures unless agreement on appointment procedure provides other means for securing appointment. And decision on matter entrusted to Chief Justice or person or institution designated by it. Chief Justice or person or of arbitrators by agreement of parties. Other considerations as are likely to secure appointment of an independent and impartial arbitrator. In case of appointment of a sole or third arbitrator in an international commercial arbitration, Chief Justice of India, Bharat, or person or institution designated by it may appoint an arbitrator of a nationality other than nationalized nationalities of parties, where parties belong to different nationalities. Chief Justice may make such scheme as it may deem appropriate for dealing with matters entrusted, where more than one request has been made to Chief Justice, different high courts or their designates. Chief Justice or designate whom request has been first made under relevant subsection shall alone be competent to decide on request. So this is just where a matter referred to arise in international commercial arbitration. Reference to Chief Justice in this case is Chief Justice of India. Where matter refers to in other sections arise in other arbitration, reference to Chief Justice in those subsections shall be constitutes as reference to Chief Justice of High Court of that area. So we are going to grounds for challenge after appointment. What's the ground for challenge? Let's see. When a person is approached in connection with its possible appointment as an arbitrator, that person shall disclose in writing circumstances likely to give rise to justifiable doubts as to its independence or impartiality. आप किसी के पास जाते हुए आपको आर्बिटर बनाएंगे तो उसको अपना लिख के देना होता है वातावरण किस जिससे डाउट ना हो, उसकी इंडिपेंडेंस पे, उसकी इम्पार्शियलिटी पे खलल ना आए, शक ना आए. An arbitrator from time of its appointment and throughout arbitral proceedings shall without delay disclose to parties in writing whatever circumstances referred to unless they have already been informed of them. An arbitrator may be challenged. चेतावनी, चैलेंज को क्या कहेंगे? An arbitrator may be challenged. Challenge means challenge कर देना. Circumstances exist that give rise to justifiable doubts. भाई शक होता है कि ऐसे वक्त आपकी circumstances हैं, वातावरण है कि आप सही तरह से ये काम नहीं कर पाएंगे और ये आपकी क्वालिफिकेशन नहीं है वैसी. He does not possess required qualifications agreed by parties if it is defined. A party may challenge an arbitrator appointed by it or in whose appointment work has been done, participation has been done, only for reasons of which becomes aware after appointment has been made. Now what is challenge procedure? That is section 13, challenge procedures. Maybe it's very boring subject, but it's very important subject for engineers, for others. They should know what is arbitration. It is statutory work, it's not ordinary work. It's a part of law of this country and every country because it saves time. So challenge procedure. Parties are free of an arbitral tribunal. आर्बिट्रल ट्रिब्यूनल के बनने के बाद 15 दिन के अंदर और आफ्टर बिकमिंग अवेयर ऑफ सर्कमस्टेंसेस रेफर टू send a written statement of reasons for challenge to arbitral tribunal. Failing agreement referred to in this section, a party who intends to challenge arbitrator shall within 15 days after becoming aware of constitution of arbitral tribunal or after becoming aware of circumstances referred to of section, this send a written statement of reasons for challenge to withdraws from its office or other party agrees to challenge, every tribunal shall decide on challenge. If challenge under procedure agreed upon by parties or under procedures is not successful, arbitral tribunal shall continue arbitral proceedings and make an arbitral award. अगर आपका चैलेंज फेल हो गया या वो नहीं मानते आर्बिट्रल ट्रिब्यूनल, आर्बिट्रल आर्बिट्रेशन ऐसे ही चलेगी और अवार्ड बनेगा. Where an arbitral award is made under section, party challenging arbitrator may make an application for setting aside such an arbitral award in accordance with section 34, that we shall go through section 34. Where an arbitral award is set aside on an application made under section 5, court may decide as to whether arbitrator who is challenged is entitled to fees or not entitled to fees. Now, arbitration is failure to appoint impossibility. What is that? Section 14, failure or impossibility to act. Mandate of an arbitrator shall terminate if that arbitrator becomes de facto unable to perform its functions or for other reasons fails to act without undue delay. अगर आर्बिट्रेटर काम नहीं कर सकता है, अपने जो उसको दिया गया है, या कोई और कारण है, फेल हो गया, डिले कर दिया, withdraws from his office or parties agree to termination of its mandate. If a controversy remains concerning grounds referred to in clause, a party may, unless otherwise agree by parties. If under this section, if controversy remains concerning any of grounds referred to, a party may, unless otherwise agreed by parties, apply to court to decide on termination of mandate. If under this section, an arbitrator withdraws from its office or a party agrees to termination of mandate of an arbitrator, it shall not imply acceptance of validity of ground referred to in this section. Then termination of mandate and substitution of arbitrators. Termination of mandate and substitution of arbitrators. Let's see what it says. In addition to circumstances referred to, mandate of an arbitrator shall terminate where it withdraws from office for whatever reason by or pursuant to agreement of parties. Where mandate of an arbitrator terminates, a substitute arbitrator shall be appointed according to rules that were applicable to appointment of arbitrator being replaced. Unless otherwise agreed by parties, where an arbitrator is replaced, hearings previously held may be repeated at discretion of arbitral tribunal. Unless otherwise agreed by parties, an order or ruling of arbitral tribunal made prior to replacement of an arbitrator under this section shall not be invalid solely because there has been a change in composition of arbitral tribunal. Rule on its jurisdiction. समता क्या है आर्बिट्रेटर की? Legal capability. Arbitral tribunal may rule on its own jurisdiction, including ruling of whatever objections with respect to existence or validity of arbitration agreement. And for that purpose, an arbitration clause which forms part of a contract shall be treated as an agreement independent of other terms of contract. A decision by arbitral tribunal that contract is null and void shall not entail ipso sure invalidity of arbitration clause. अगर सारा भी कॉन्ट्रैक्ट कहा जाए कि गलत है, इनवैलिड है, तब भी आर्बिट्रेशन क्लॉज इनवैलिड नहीं होगा, चलता रहेगा. A plea that arbitral tribunal does not have jurisdiction shall be raised not later than submission of statement of defense. A plea that arbitral tribunal does not have jurisdiction shall be raised not later than submission of statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed a party or participated in appointment of an arbitrator. A plea that arbitral tribunal does not have jurisdiction shall be raised not later than submission of defense statement. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in appointment. A plea that arbitral tribunal is exceeding scope of its authority shall be raised as soon as matter alleged to be beyond scope of its authority is raised during arbitral proceedings. Arbitral tribunal may, in either of cases referred, admit a later plea if it considers delay justified. Arbitral tribunal shall decide on a plea referred to where arbitral tribunal takes a decision rejecting the plea. Continue with arbitral proceedings and make an arbitral award. A party aggrieved by such an arbitral award may make an application for setting aside such an award in accordance with section 34 of VCDA 1. Measures ordered by arbitral tribunal. It's also sometimes very important what we say. Interim measures ordered by arbitral tribunal, unless otherwise agreed by parties. Arbitral tribunal may, at request of a party, order a party to take interim measures of protection as arbitral tribunal may consider necessary in respect of subject matter of dispute. Arbitral tribunal may require a party to provide appropriate security in connection with a measure ordered under subsection 1. Now, equal treatment of parties. Parties shall be treated with equality and each party shall be given a full opportunity to present case. Determination of rule of procedure. Arbitral tribunal shall not be bound by Code of Civil Procedures 1908 or Indian Evidence Act 1872. In this act, there is no mandate that Code of Civil Procedure must be complied with or Indian Evidence Act must be complied with. Subject to this part, parties are free to agree on procedure to be followed by arbitral tribunal in conducting its proceedings. Remember, we are just talking original act. Its amendments we will talk later on, just for your information. Failing agreement referred to arbitral tribunal may, subject to this part, conduct proceedings in manner it considers appropriate. Power of arbitral tribunal includes power to determine admissibility, relevance, materiality and weight of evidence. In this act, place of arbitration, parties are free to agree on place of arbitration. Failing agreement referred to place of arbitration shall be determined by tribunal having regard to circumstances of case, including convenience of parties. Notwithstanding, arbitral tribunal may, unless otherwise agreed by parties, meet at whatever place it considers appropriate for consultation among its members, for hearing witnesses, experts or parties, or for inspection of documents, goods or other property. Commencement of arbitral proceedings. Arbitral proceedings की शुरुआत. Commencement of arbitral proceedings, unless otherwise agreed by parties. Arbitral proceedings of a particular dispute commence on date on which a request for that dispute to be referred to arbitration is received by respondent. Again, unless otherwise agreed by parties, arbitral proceedings in respect of particular dispute commence on date on which a request for that dispute to be referred to arbitration is received by respondent. Parties are free to agree upon language or languages. Parties are free to agree upon language or languages to be used in arbitral proceedings. Failing agreement referred to, arbitral tribunal shall determine language or languages to be used in arbitral proceedings. Agreement or determination, unless otherwise specified, shall apply to whatever written statement by party, whatever hearing and whatever arbitral work, decision or other communication by arbitral tribunal. Arbitral tribunal may order that whatever documentary evidence shall be accompanied by translation into language or languages agreed upon by parties or determined by arbitral tribunal. Statement of claims and defense. Statement of claims and defense. Within period of time agreed upon by parties or determined by tribunal, claimant shall state facts supporting his claims. Claimant shall state facts supporting its claim, points at issue, and relief or remedy sought. Respondent shall state its defense in respect of these particulars, unless parties have otherwise agreed as to required element of those statements. Parties may submit with their statement. Parties may submit with their statements all documents they consider to be relevant or may add a reference to documents or other evidence they submit or they shall submit. Unless otherwise agreed by parties, either party may amend or supplement its claim or defense during course of arbitral proceedings. Unless arbitral tribunal considers it inappropriate to allow amendment or supplement having regard to delay in making it. Hearings and proceedings. Hearing and proceedings. Unless otherwise agreed by parties. Unless otherwise agreed by parties, arbitral tribunal shall decide whether to hold oral hearing for presentation of evidence or for oral argument, or whether proceedings shall be conducted on basis of documents and other materials. This is original provision. There may be some amendment on this, we'll see. So unless otherwise agreed by parties, arbitral tribunal shall decide whether to hold oral hearings for presentation of evidence or for oral argument, or whether proceedings shall be conducted on basis of documents and other materials, provided that arbitral tribunal shall hold oral hearings at appropriate stage of proceedings on a request by party. Unless parties have agreed that no oral hearing shall be held, parties shall be given sufficient advance notice of whatever hearing and of whatever meeting of arbitral tribunal for purpose of inspection of documents, goods or other property. All statements, documents or other formal information supplied to or applications made to arbitral tribunal by one party shall be communicated to other party, and whatever expert report or evidentiary document on which arbitral tribunal may rely in making its decision shall be communicated to parties. Default of a party. Default of a party. Unless otherwise agreed by parties, where without showing sufficient cause, claimant fails to communicate its statement of claim in accordance with required format, arbitral tribunal shall terminate proceedings. Respondent fails to communicate its statement of defense in accordance with default of a party. Unless otherwise agreed by parties, where without showing sufficient cause, Claimant fails to communicate his statement or claim in accordance with section, arbitral tribunal shall terminate procedures. And same applies for other one. So we can say respondent fails to communicate its statement of defense in accordance with requirement. Arbitral tribunal shall continue proceedings without treating that failure in itself as an admission of allegation by complainant. Default is inverse is claim failed if claimant unless otherwise agreed by parties where without showing sufficient cause claimant fails to communicate its statement of claim in accordance with this requirement, the arbitral tribunal shall terminate proceedings. Or respondent fails to communicate its statement of defense in accordance with requirement, arbitral tribunal shall continue proceedings without treating that failure in itself as an admission of allegation by claimant. A party fails to appear at an oral hearing or to produce documentary evidence, arbitral tribunal may continue proceedings and make arbitral award on evidence before it. Then expert appointment by arbitral tribunal. Experts appointment. Unless otherwise agreed by parties, arbitral tribunal may unless otherwise agreed by parties, arbitral tribunal may appoint one or more experts to report to it on specific issues to be determined by arbitral tribunal. Require a party to give expert whatever relevant information or to produce or to provide access to whatever relevant documents, goods or other property for its inspection. Unless otherwise agreed by parties, if a party so requests or if arbitral tribunal considers it necessary, expert shall, after delivery of its written or oral report, participate in an oral hearing where parties have opportunity to put questions to it and to present expert witnesses in order to testify on point at issue. Unless otherwise agreed by parties, expert shall, on request of a party, make available to that party for examination all documents, goods or other property in possession of expert with which it was provided in order to prepare support. Unless otherwise agreed by parties, expert shall, on request of a party, make available to that party for examination all documents, goods or other property in possession of expert with which it was provided in order to prepare support. Court assistance in taking evidence. Arbitral tribunal or a party with approval of arbitral tribunal may apply to court for assisting in taking evidence. Application shall specify names and address of parties and arbitrators, general nature of claim and relief sought, evidence to be obtained in particular, name and address of person to be heard as witness or expert witness, and a statement of subject matter of testimony required. description of whatever document to be produced or property to be inspected. Court may, within its competence and according to its rules, or taking evidence, execute request by ordering that evidence be provided directly to arbitral tribunal. Court may, while making an order, issue same process to witnesses as it may issue in suits tried before it. Persons failing to attend in accordance with such process or making any other default, whatever else default, or refusing to give evidence are guilty of whatever contempt to arbitral tribunal during conduct of arbitral proceedings shall be subject to like disadvantages, penalties and punishments by order of court on representation of arbitral tribunal as they would incur for like offences in suits tried before court. In this section, expression process includes summons and commissions for examinations of witnesses and summons to produce documents. Rules applicable to substance of dispute. What is substance and what are rules? Where place of arbitration is situated in India, it is an arbitration under that, and an arbitration under that, other than international commercial arbitration, arbitral tribunal shall decide dispute submitted to arbitration in accordance with substantial to law for time being in force in India. In international commercial arbitration, arbitral tribunal shall decide dispute in accordance with rule of law designated by parties as applicable to substance of dispute. Any designation, whatever designation by parties of law or legal system of a given country shall be constituted unless otherwise expressed as directly referring to substantial law of that country and not its conflict of law rules. Arbitral tribunal shall decide dispute in accordance with rules of law designated by parties as applicable of the substance of dispute, and designation by parties of law or legal system of a given country shall be construed as directly referring to substantial law of that country and not to its conduct of law rules. Failing designation of law under clause by parties, arbitral tribunal shall apply rules of law it considers to be appropriate given all circumstances surrounding dispute. Arbitral tribunal shall decide ex equito et bono or as amicable, compositor only amiable if parties have expressed authorized to do so. In all cases, arbitral tribunal shall decide in accordance with terms of contract and shall take into account usages of trade applicable to transaction. Arbitrators, the panel of arbitrators. Unless otherwise agreed by parties, in arbitral proceedings with more than one arbitrator, decision of arbitral tribunal shall be made by a majority of all its members, notwithstanding if authorized by parties or all members of arbitral tribunals, questions of procedure may be decided by presiding arbitrator. Power to award interest. It's only comment. So just I'll read it for information, otherwise I'll go to settlement. Where arbitrators has awarded interest from date of award till date of payment, disallow interest from date of decree or determine a different rate at which interest is to be paid, or confirm grant of interest as awarded in award. In that instant case, arbitrator is entitled to grant pre-reference, pendent light, and future interest. However, claimant did not claim any pre-reference interest in proceedings before arbitrator in present facts and circumstances could not have granted interest from date of arbitrator entered upon reference by sending notice to claimant and respondent. Leave it now. Settlement. It's not incompatible with an arbitration agreement for an arbitral tribunal to encourage settlement of disputes, and with agreement of parties, arbitral tribunal may use mediate, conciliation, or other procedures at whatever time during arbitral proceedings to encourage settlement. If during arbitral proceedings parties settle dispute, arbitral tribunal shall terminate proceedings, and if requested by parties, not objected to by arbitral tribunal, record settlement in form of an arbitral award on agreed terms. An arbitral award on agreed terms shall be made in accordance with section 31C, what's that, following just now, and shall state that it's an arbitral award. An arbitral award on agreed terms shall have same status and effect as whatever other arbitral award on substance of dispute. Form and contents of arbitral award. An arbitral award shall be made in writing and signed by members of arbitral tribunal. For purpose in arbitral proceedings with more than one arbitrator, signatures of majority of members of tribunal shall be sufficient so long as reason for whatever omitted signatures stated. An arbitral award shall be made in writing and shall be signed by all members. For purpose of this arbitral proceedings with more than one arbitrator, signatures of majority of all members of arbitral tribunal shall be sufficient so long as reason for omitted signatures stated. Arbitral award shall state reasons upon which it is based, unless parties have agreed that no reason are to be given. Means reasons must if parties don't agree. Award is an arbitral award on agreed terms under section 30. Arbitral award shall state its date and place of arbitration as determined in accordance with section 20, and award shall be deemed to have been made at that place. After arbitral award is made, a signed copy shall be delivered to each party. Arbitral tribunal may, at whatever time during arbitral proceedings, make an interim award on whatever matter with respect to which it may make a final arbitral award. Unless otherwise agreed by parties, where and so far as an arbitral award is for payment of money, arbitral tribunal may include in sum which award is made interest at such rate as it deems reasonable on whole or on part of money, for whole or by part of period between date on which cause of concern, cause of action arose and date on which award is made. A sum directed to be paid to a sum directed to be paid by an arbitral award shall, unless award otherwise directs, carry in tribunal shall specify party entitled to cost, party who shall pay cost, amount of cost, or method of determining that amount, manner in which cost shall be paid. Cost means reasonable cost relating to fees and expenses of arbitrators and witnesses, legal fees and expenses, admission fee, administration fee of institution supervising arbitration, and other expenses incurred in connection with arbitral proceedings and an arbitral award. Termination of proceedings. Arbitral proceedings shall be terminated by final arbitral award or by an order of arbitral tribunal. Arbitral tribunal shall issue an order for termination of arbitral proceedings. Arbitral tribunal shall issue an order for termination of arbitral proceedings where claimant withdraws its claim unless respondent objects to order and arbitral tribunal recognizes a legitimate interest on its part in obtaining a final settlement of dispute. Parties agree on termination of proceedings or arbitral tribunal finds that continuation of proceedings has for within 30 days from receipt of award, arbitral award, unless a period of time has been agreed upon by parties. A party with notice to other party, a party with notice to other party may request arbitral tribunal to correct whatever computation errors or whatever clerical or typographical errors or whatever other errors of a similar nature occurring in award. A party with notice of the party may request an arbitral tribunal to correct any computation error, whatever clerical or typographical error, or whatever other errors of a similar nature occurring in award. If so agreed by parties, a party with notice to other party may request the arbitral tribunal to give an made under this section to be justified. It shall make correction or give interpretation within 30 days from receipt of request, and interpretation shall form arbitral award. If arbitral tribunal may correct whatever error of type related in this clause on its own initiative within 30 days from date of arbitral award. Unless otherwise agreed by parties, a party with notice to other party may request within 30 days from receipt of arbitral award. Arbitral tribunal to make an additional arbitral award as to claims presented in arbitral proceedings but omitted from arbitral award. If arbitral tribunal considers request made under this section to be justified, it shall make additional arbitral award within 60 days from receipt of such request. So what provision is, unless otherwise agreed by parties, a party with notice to other party may request within 30 days from receipt of arbitral award, arbitral tribunal to make an additional arbitral award as to claims presented in arbitral proceedings but omitted from arbitral award. If arbitral tribunal considers request made to be justified, it shall make additional arbitral award within 60 days from receipt of such request. Arbitral tribunal may extend if necessary period of time within which it shall make a correction, given interpretation, or make an additional arbitral award. Section 33 shall apply to a correction or interpretation of award or to an additional arbitration award made under this section. Out was setting aside. This is 34, which we said will have certain amendments. Let's go first to original one. I want to read original act so that we can talk of amendment 2015 or whatever else is there. That's also a very important point. Now, it says application for setting aside arbitral award. Recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection. An arbitral award may be set aside by court only if or arbitration agreement is not valid under law to which parties have subjected it, or failing whatever indication thereon under law for time being in force. Party making application was not given proper notice of appointment of an arbitrator or of arbitral proceedings, or was otherwise unable to present his case. Arbitral award deals with the dispute not contemplated. Arbitral award deals with a dispute not contemplated by or not falling within terms of submission of arbitration, or it contains decisions or matters beyond scope of submission to arbitration, provided if decisions on matters submitted to arbitration can be separated from those not so submitted. Only that part of arbitral award which contains decisions on matters not submitted composition of arbitral tribunal or arbitral procedure was not in accordance with agreement of parties unless such agreement was in conflict with a provision of this part from which parties cannot derogate, or failing such agreement was not in accordance with this part. Court finds that subject matter of dispute is not capable of settlement by arbitration under law for time being in force, or arbitral award is in conflict with public policy of this country. An application for just a minute, let me see. Okay. An application for setting aside may not be made after 3 months have elapsed from date on which party making that application had received arbitral award, or if a request has been made under section. Now 33 is that from date on which that request had been disposed of by arbitral tribunal, provided that if court is satisfied that application was prevented by sufficient cause, applicant was prevented by sufficient cause from making application within said period of 3 months, it may entertain application within further period of 30 days, but not thereafter. On receipt of application under section, the section court may, where is appropriate and is so requested by party, adjourn proceedings for a period of time determined by it, in order to give arbitral tribunal an opportunity to resume arbitral proceedings or to take such other action as in opinion of arbitral tribunal shall and that is arbitration court cannot interfere on the ground of award being erroneous. Arbitration court cannot interfere with award on ground that award is erroneous if award is otherwise proper. It's not open to arbitration court to reappreciate reasonableness of reasons in arbitral award. Account of overlook. Award made by arbitrator was partially vitiated on account of overlooking contents of document be brought to its notice, and therefore to that extent award should have been modified by High Court. Virtually allotment of land was not in acquisition limit. Court must not look to reasonableness of reasons where an arbitrator passed a non-speaking award granting certain lump sum amount and award did not contain any decision or arbitrarity of claims, award is liable to be set aside. Interpretation with arbitral award. While considering legality and validity of award, High Court cannot substitute its own findings as if sitting in appeal over award. High Court has no jurisdiction to interfere with award. And limitations. It is axiomatic that arbitrator being a creative of agreement must operate within 4 corners of agreement and cannot travel beyond it. Most particularly, cannot award amount which is ruled out or prohibited by terms of agreement. Okay, right. Enforcement. I think you have to give me a few minutes, right? As usual. Just a few minutes so that I come back, right? Just if you excuse me for that, I'll be back. Okay. I'm sorry, gentlemen, a little late I was. What to do? Life is like that. We have to move somewhere here. Enforcement. I'm talking of enforcement now. Enforcement where 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 time for making where time for making an application to set aside arbitral award has expired. Such application having been made, it has been refused. The award shall be enforced under Code of Civil Procedures 1908 in same manner as if it were a decree of court. Appealable orders. Appealable orders. An appeal shall lie from following orders. An appeal shall lie from following orders and from no others. To court authorized by law to hear appeals from original decrees of court passing order, namely granting or refusing to grant whatever measure under section 9, setting aside or refusing to set aside an arbitral award under section 34. An appeal shall also lie to a court from an order granting arbitral tribunal accepting plea referred in sections or granting or refusing to grant an interim measure. No second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect or take away any right to appeal to Supreme Court. Arbitral tribunal may fix amount of deposit or supplementary deposit as case may be, as in advance for cost referred in subsection which it expects shall be incurred in respect of claim submitted. Provided that where apart from claim a counterclaim has been submitted to arbitral tribunal, it may fix separate amounts of deposit for claim and counterclaim. Deposit referred to shall be payable in equal shares by parties. Provided that one party fails to pay its share of deposit, other party may pay that share. Provided further that where other party also does not pay aforesaid share in respect of claim or counterclaim, arbitral tribunal may suspend or terminate arbitral proceedings in respect of such claim or counterclaim as case may be. Upon termination of arbitral proceedings, arbitral tribunal shall render an accounting to parties of deposits received and shall return any unexpended balance to party or parties. Arbitration. Lien on arbitral award and to whatever provision to contrary in arbitration agreement. Arbitral tribunal shall have a lien on arbitral award for whatever unpaid cost of arbitration. If in whatever case an arbitral tribunal refuses to deliver its award except on payment of costs demanded by it, court may on an application in this behalf order that arbitral tribunal shall deliver arbitral award to applicant on payment into court by applicant of cost demanded, and after such inquiry whatever as it thinks fit, further orders that out of money in arbitrator and that party. An arbitral tribunal shall be entitled to appear and be heard on whatever such application. Court may make such orders as it thinks fit respecting cost of arbitration, where whatever question arises respecting such costs and arbitral award contains no sufficient provisions concerning them. Arbitration agreement not to be discharged by death of party thereto. An arbitration agreement shall not be discharged by death of any party thereto, either as respects deceased or as legal representative of deceased. Mandate of an arbitrator shall not be terminated by death of any party by whom he was appointed. Nothing in this section shall affect operation of whatever any law by virtue of which is a party, where it is provided by term in a contract to which an insolvent is a party, that whatever dispute arising thereto, thereout, or in connection therewith shall be submitted to arbitration. Said term shall, if receiver adopts contract, be enforceable by or against it so far as it relates to any such dispute. Provisions in case of insolvency. Where it is provided by term in a contract to which an insolvent is a party, that whatever dispute arising thereout or in connection therewith shall be submitted to arbitration. Said term shall, if receiver adopts contract, be enforceable by or against it so far as it relates to whatever such dispute. Where a person who has been adjudged where a person who has been adjudged an insolvent had before commencement of insolvency proceeding becomes a party to an arbitration agreement, and whatever matter to which agreement applies is required to be determined in connection with or for purposes of insolvency proceedings, then if case is one to which this section does not apply, other party, whatever other party or receiver may apply to judicial authority having jurisdiction in insolvency proceedings for an order directing that matter in question shall be submitted to arbitration in accordance with arbitration agreement, and judicial authority may, if it is of opinion that having regard to all circumstances of case matter ought to be determined by arbitration, make an order accordingly. In this section, expression receiver includes officer assignee. Jurisdiction. Jurisdiction. Notwithstanding whatever contained elsewhere in this part or in whatever other law for time being in force, where with respect to an arbitration agreement, application under this part has been made in court, court alone shall have jurisdiction over arbitral proceedings, and all subsequent applications arising out of agreement and arbitral proceedings shall be made in that court in no limitations. Limitation Act 1963 shall apply to arbitrations as it applies to proceedings in court. For purposes of this section, Limitation Act 1963, an arbitration shall be deemed to have commenced on date referred to, where an arbitration agreement, wherein arbitration agreement to submit future disputes to arbitration provides that whatever claim to which agreement applies shall be barred unless some step to commence arbitral proceedings is taken within a time fixed by agreement. And a dispute arises to which agreement applies, court, if it is of opinion that circumstances of case undue hardships would otherwise be caused, and notwithstanding that time so fixed has expired, may on such terms, if whatever as justice of case may require, extend time for such period as it thinks fit. Award means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under law in force in India, made on after 11th day of October 1960, in pursuance of an agreement in writing for arbitration to which in one of such territories as central government in one of such territories as central government being satisfied that reciprocal provisions have been made, maybe by notification official gazette. In one of such territories as central government being satisfied that reciprocal provisions have made may by notification official gazette declare to territories to which said convention applies. In this chapter, unless a contest requires, foreign award means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considers a commercial under law in force in India, made in after 11 October 1960, a pursuance of agreement in writing for arbitration to which convention set forth in first schedule applies. In none of such territories as central government being satisfied that reciprocal provisions have been made may by notification official gazette declare to be territories to which state commission applies. 45. Power of judicial authority to refer parties to notwithstanding anything contained in Part 1 on Code of Civil Procedures 1908, a judicial authority when seized of an action on a matter in respect of which parties have made an agreement referred to Section 44 shall at request of one of parties or whatever person claiming through or under it refers parties to arbitration unless it finds that said agreement is null and void, inoperative or incapable of being performed. 46. When foreign award binding. And may accordingly be relied on by whatever of those persons by way of defense, set off or otherwise in whatever legal proceedings in India and whatever references in this chapter to enforcing a foreign award shall be construed as including references to relying on an award. Evidence. Persons applying for enforcement of a foreign award shall at time of replication produce before court what original award or a copy thereof duly authenticated. Original agreement for arbitration on a duly certified copy thereof and such evidence as may be necessary to prove that section is in foreign language, party seeking to enforce award shall produce a translation into English certified as correct by a diplomatic or consular agent of country to which that party belongs to, or certified as correct in such a manner as may be sufficient according to law in force in India. Conditions for enforcement of foreign awards. Enforcement of foreign award may be refused at request of party against whom it is invoked, only if that party furnishes to court proof that parties to agreement referred to in section 44 were the law applicable to them under some incapacity, or said agreement is not valid under law to which parties have subjected it, or failing indication, whatever indication thereon under law of country not contemplated by or not falling within terms of submission to arbitration, or it contains decisions on matters beyond scope of submission to arbitration, provided that if decisions on matters submitted to arbitration was not in accordance with law of country where arbitration took place or happened. Award has not yet become binding on parties or has been set aside or suspended by a competent authority of country in which, under law of which, that award was made. Enforcement of arbitral award may also be refused by if court finds that subject matter of difference is not capable of settlement by arbitration under law of India, or enforcement of award would be contrary to public policy of India. If an application for setting aside suspension of award has been made to a competent authority referred to clause, court may, if considers proper, adjourn decision and enforcement of award, and may also on application of party claiming enforcement of award order of other party to give suitable awards. Where court is satisfied that foreign award is enforceable under this chapter, award shall be deemed to be a decree of that court. Appealable orders. An appeal shall lie from order refusing to an appeal shall lie from order refusing to refer parties to arbitration under section 45, enforce a foreign award under section 48, to court authorized by law to hear appeals from such order. No second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect, take, or take away any right of appeal to Supreme Court. So these are 50 31st December. And it says this act may be called Arbitration and Conciliation Amendment Act 15 plus 15. And there some court is redefined, or you can say here which is original court of jurisdiction, and company versus company has been omitted from that clause, and Principal Act afterwards, other military questions. There is no Section 7 of Principal Act out of any interim measure says following section shall be inserted, namely what the insertion is, where before commencement of arbitral, commencement of let me say 150, so that you can look it, where before commencement of arbitral proceedings it passes an order for whatever interim measure of protection under subsequent arbitral proceedings shall be commenced within a period of 90 days from date of such order, or in such further time as court may determine. That is, where before commencement of arbitral proceedings, the court passes an order for interim measures of protection. Arbitral proceedings shall be continued commenced within a period of 90 days from date of such order, or within such further time as court may determine. Once arbitral tribunal has been constituted, then in this section 11 of Principal Act, in subsection 456 forwards Chief Justice or any person or institution designated by it, whenever they occur, words Supreme Court, or as case may be High Court, or any person or institution maybe High Court, while considering application under this section 4 and 5 or 6 shall not withstanding any judgment, decree, or order of any court confined to examination of existence of an arbitration agreement. Designation of person or institution by Supreme Court, case may be High Court, for purpose of this section shall not be regarded as a delegation of justice power by Supreme Court, shall not be regarded designation of any other person or institution by Supreme Court, as case may be High Court, for purpose of this section shall not be regarded as delegation of judicial power by Supreme Court or High Court. And forwards Chief Justice is in section 6, 7, Chief Justice or person or institution designated by it. Final word Supreme Court, or as case may be High Court or person or institution designated by such court is final, not no appeal, including latest patent appeal, shall lie against such decision. Supreme Court in subsection 8 following subsection shall be substituted, and that is Supreme Court, or as case may be High Court or person or institution designated by such court, before appointing an arbitrator shall seek a disclosure in writing from prospective arbitrators in terms of